mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Okay, besties, time to buckle up, because tonight's going to be a roller coaster, and not the fun Disneyland kind. More like the kind you regret getting on and then you can't get off because the bar already locked. But before we start, hit that like and subscribe button and help us increase the size of this channel to help increase the size of my other channel, which is my baby, my heart and soul. And I recorded a new video over there this morning. Hopefully it will be up on Wednesday, holiday weekend craziness or holiday week craziness. Hope everybody is doing well. But now listen, I know I love y'all. I love y'all. And I know some of y'all are Jeremy Hale super fans, and I love that for you. I really, 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 really do. But some of you are already in my chat with your emotional support pitchforks, ready to throw those rotten digital tomatoes at me and riot. And you haven't even heard the first sentence yet. So let's take a deep breath. Inhale the logic. Exhale the emotion, please. Because today is going to be one of those magical evenings where the law is probably going to say, "Oh, that's sad, but not my fucking problem." So y'all are going to be mad. And here's the petty truth. Just because something in this world is shady, unfair, petty, morally gross, and if something's being, or someone is being a grade A grass-fed jerk, does not necessarily make it illegal and actionable under the law. The law does not care about your feelings. The law does not care about your group chats. The law does not care about who you simp for. And yes, you, the lurkers, right there, you should absolutely stick around, because that's going to make you yell at me in all caps. And I can't fucking wait. But we haven't even got there yet. So before you start typing, "I'm biased, I'm making money off this, I'm defending them," I'm begging you, just listen. Just listen. Let's read. Let's look at the case law. Let's look at the Florida statutes. Because trust me, if you think you're going to be mad at me, you're going to be even madder at the law. And here is where we get a little... Before we get started, we have our Petty chat rules. Use your inside voice, all caps, is not a algorithm killer, but it's a cry for help. If anybody ever tells you that it messes with the algorithm, they're either a thunder cunt or they're lying to you, or both. Feelings are valid, they're just not admissible in court. And yes, Heather hates immunity. She knows, we know, the government knows. Bring receipts, not your Facebook vibes. Don't fight each other. Save that energy for the statutes that deserve it. If you're offended, congratulations, you're finally paying attention. No diagnosing the host. She's petty, but not pathological. Do not summon the mods. They're tired and they're ready to drop the band hammer. And if you disagree, amazing, type faster. The algorithm loves you. And remember, we drag the law here, not each other. Stay cute. That is my rules. Do not break my rules. If you break my rules, my mods will break you with their band hammers. I'm prepared, and this is what happens when I'm prepared. It's fucking weird. It's fucking weird. Hey, Squid, looking well. I'm doing okay. Hey, common sense. Some should look up the word simp because I predict some are crazy and liar nuts. And there's simps on both sides. I'm sorry. In my comment section and the chat recently, anytime I disagree, with Jeremy, or something Jeremy or Randy do, or the way they write, people come at me all the fucking time. I am here and I call it like it is. I am loyal to, well, I'm loyal to people who are loyal to me. But as far as the facts go, I'm loyal to the facts, not the person. Yes, the facts tend to lead towards one side in certain instances in things, just not necessarily this. So give me 1 second. There we go. Got to open chat. There we go. Alrighty. So first things we're going to get to today is Hung Hero. Thank you for being a member for 14 months. 14 months, where has the time gone? I don't know. And Hero, thanks for gifting 10 Squid Pro Club memberships. I really appreciate you. You have absolutely no idea how much you matter to me and my channel. With that being said, we are going to get into the is the new member, is that the well, I don't fucking know. People got, oh no, I don't know. I don't know. I don't claim to, ever since YouTube changed the way these things work again, I have hard time keeping up with who people are. So if, you know, yeah. Who am I breaking? And Roy, I'm so happy for you. I hope you are, and the misses, more importantly, are doing well today. All right. Squid knows where I stand on this motion. Even before the motion was filed, I said it was a tough nut to crack, and the statute and precedent is well established. Yes, this is going to be a this is going to be one where y'all are going to hate me because the law is not going to be, I don't believe the law in this first motion that we're going to cover is going to be on our side. And hey, Dad, just to inform you, Baby Squid and I are done FaceTiming. Sweet. Maybe I can get my phone back so I can plug it in because it's almost dead. And Roy, thanks for being a 14 months listening from the hospital room. Hopefully, y'all are on your way home today. Jeremy supporters are as bad as the fleas and believing everything he says. Yeah, it's like, and there are people in the middle, and just like everything in life, there are people in the middle. But some people, it's yeah. Some people are like on both sides. Don't believe anything he says, And then some people believe everything he says. There's got to be somewhere in the middle is where the actual truth and the facts lie. I'm just, yeah, we're going home today. Woohoo! Woohoo! Oh, and Roy, can I tell the chat the exciting news about the fact that y'all are going home today and what that entails? Not the oxygen part, because you said it was just delivered, but can I tell the other part? Can I share who is Tammy J? Like, I don't know that like I know that name, but there's like 800 Tammys. So I don't know which that is. That the one that absolutely hates me? Mrs. Roy Loss and Roy, if I pronounce her last name, Lossinger, she is done with her chemo. She had a CT last week. She has an infection right now because of the chemo. It's being handled. She's being discharged. However, she is done with chemo. 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 She is officially in remission, from what I understand. So, yay! She's done. Yeah. From what Roy has told me, the tumor did not show up on the CT scan. So, congratulations to her. I am so happy to hear that. Yes, cancer meter. Yay! Sorry, I know there's a balloons or something I can do in here, but there we go, balloons. Got it. Got it. Sorry, that made my day. I mean, I'm sure it made hers. I'm sure it made theirs too. But it made my day so much better. So if I look well rested and like I'm happy, it's because I got good news today. But we are going to get into this first motion. We're going to get through this as fast as possible because there are 2 new motions in federal 2, but this is federal 3. Oh, we're going to do this one first. My bad. We're going to do the one where y'all hate me. Y'all hate me. Y'all are going to hate me. And you know what? Y'all are going to hate me, and it's okay because yep. Oh, so Tammy J is a okay. Okay, I'm not going to lie, y'all. I enjoy when people are members. There will be more members content. I appreciate every single member of this channel, whether they were gifted memberships or they purchased their memberships on their own. However, these gifted memberships really be outing some people. Really be outing some people. Like, really be outing some people. Yeah. So, federal 3. I call it federal 3. I don't actually know. It's the lawsuit that Jeremy filed against Rex Owens or Daniel Owens, Rex Owens, whatever. I couldn't pick this man out of a fucking lineup. So I am literally only interested in the cases here and like how it impacts the case law. And the cases are interesting to me. I am not super interested in the people and the drama because like someone emailed me today and I'm sorry, they blind carbon copied me on an email. And if this person, just because we have some of the same people that annoy me or I don't talk to on a regular basis are people you despise, that does not make us friends. Do not email me ever again. Ever again. Ugh. Ugh. I saw that name in my email today and thought I was going to vomit. You can't hide behind the gifted memberships. LOL. Surprise! Like, it's I'm only here for the train wreck. No hate. Yeah, but it really does be outing people. Hung hero. Give your wife my best. Thanks for the $5 super chat. And part of why I gift memberships, yes, it helps the channel and it exposes your lurkers. Oh, good Lord. Oh, I appreciate you so much. All right. Get ready to by those fingertips. And remember, thank you for helping the algorithm, even the hate watchers. But there's people who started YouTube channels so that I wouldn't get views. So I've been told. Those were fun. Those were fun DMs this weekend. Oh, by the way, this person only has only was forced to start his YouTube channel so you would get less views. Make that one make sense. All right. We before y'all hate on me. This is not this is going to suck. This is where it is. Just because someone is a grade A grass-fed jerk does not mean that is an actionable offense under the law, especially when it comes to immunity. All right. Defendant's motion to dismiss moves. Daniel Owen moves to dismiss complaint document 1 under FRCP 12B. Mr. Owen is absolutely immune from suit. Plaintiff fails to state a claim on which relief can be granted. Mr. Owen is entitled to qualified immunity. Blech. Blech. Background, we all know Preston filed a petition for temporary restraining order in Levy County. I'm going to skip over this background because I'm sorry, like, if you don't know the background by now. Around the same time, Hales filed a petition for a restraining order against Preston and Cook in Summit County, Ohio. Summit County, Ohio Civil Protection Order issued November 1st, 2023, expired in October 10th of 2025. Levy County Temporary Injunction issued on December 4th, 2023, and terminated at Preston's request on September 4th of 24. Hales and Risk each reported violations of their protection orders to Levy County Sheriff's Office and the Judicial Circuit State Attorney. Filed charges in Levy County, State v. Preston. State v. Preston filed April 5th, 2024. State v. Cook filed July 11th, 2024. Charges were dropped. Plaintiff then sued Preston and Cook in Northern District of Florida on March 4th, 2024. Preston sued plaintiff in Levy County. Preston filed for Chapter 7 bankruptcy in Northern District of Florida, resulting in entry into automatic stay on plaintiff's federal lawsuit on July 15th. A few months later, plaintiff filed lawsuit against the 8th Judicial Circuit of Florida attorney Daniel Owen for alleged failure to enforce the protection orders against Preston and Cook. I do not know if I don't think so. I don't think the state attorneys are elected in Florida. I could be wrong. I don't live in Florida. I don't know. And honestly, I didn't look. But it just seems. I have not seen anything to say that it has, but like unless Jeremy showed actual paperwork, what people say, and this is nothing against Jeremy, nothing against anybody who streams, but unless I see paperwork, the last paperwork that I saw that was included as an attachment, an exhibit to a lawsuit, said it expired October 10th, and there was nothing that ever extended it. So each circuit state attorney is elected, but the Owen is using his immunity similar to the judge. Yeah, I'm. We all know how I feel about immunity, so I'm not going to get into that. But you know, and Rick Reed, thanks for being a member for 4 months. Appreciate you, Jeffrey. I reached the 8-month mark. Time to watch Heather's. You're almost to a baby squid. 9 months. Thanks, Malin. 132 of us here, only 47 likes. How lazy are we? Because 100 people probably don't like me and are only hate watching me. So, there's that. Hey, you gotta love me. And Janet, thanks for being a member for 4 months. So here's the plaintiff's allegations. And while I agree with Jeremy that this was some shady shit, we're going to look at some case law, and I actually have the case law brought up in the statute to, yeah. Plaintiff's allegations here derive from the Ohio Civil Protection Orders, according to the complaint. That's where I saw the Civil Protection Orders. Docs 1, Exhibit 1 and 2 for Document 1. According to the complaint, plaintiffs were in Florida on at least 3 occasions between November 23rd and November 2023 and May 2024. Plaintiff brought the protection order to the Levy County Sheriff's Office and requested enforcement. Levy County Sheriff's Officer Beauchamp, who fucking cares at this point, emailed, sorry, it's one of those things that I really, yeah. Mr. Owen for assistance. Mr. Owen is currently a Division Chief for the 8th Judicial Circuit, State's Attorney's Office. In an email to the Levy County Sheriff, Mr. Owen wrote, "Can you email me the petition that so-and-so," we all know what the redacted part is, "filed in order to obtain this order of protection. If you don't have a copy, please request one from the clerk of Summit County. I want to see if he committed perjury in the petition. Specifically, I want to see what representations he made to that residence. My understanding is that we all know Preston and Cook have no ties to Ohio, much less Summit County, Ohio." So, when Ms. Risk requested enforcement several weeks later, on November 20th, 2023, a different sheriff's deputy, S. Williamson, wrote an incident report stating he had reviewed Mr. Owen's email, and it reads that defendant would caution against enforcing this injunction. Officer Williamson informed Risk that a report would be created for documentation only. And that to me is just lazy. Like, sure, I'll take your word for it. I'm not going to take your word for it. I don't mean to be rude. Then I'm not trying to be rude, but so I am usually a back the blue kind of person, but I'm also a call bullshit when I see it. And this whole county seems to be twisted. So I'm kind of like, me, eh. Oh no. I hope your grandchild is feeling better. Ugh. Sheriff's Office responded to plaintiff's report about protection order violations resulting in charges against the restrained parties. Plaintiffs claim Mr. Owen's investigation into the protection order amounted to a refusal to enforce the protection orders, and that Mr. Owen's investigation caused physical harm and threats of harm, caused mental and emotional distress because of the restrained non-parties' intimidating and threatening behavior, assault with a pew-pew, caused plaintiffs fear of death and bodily injury from the restrained non-parties' obsessive behavior, and caused financial harm because of the restrained non-parties were emboldened. It's not clear whether plaintiffs believe that Mr. Owen failed to take some action to protect them, that Mr. Owen is liable for the sheriff's office interpretation of his email as advice not to enforce the protection order, or that Owen's investigation alone amounted to a constitutional injury. I have problems with this. And I don't want, like, this is where I was talking to a couple people over the last couple of days about this, because I showed a preview of this on my members only live stream on Saturday. And the more I was reading through it, it sucks because of the situation that in this country, and this is not a Jeremy problem. This is, I take that as it's not a Jeremy specific problem. It's not a Jeremy isolated problem. It's a countrywide problem that with stalking behavior, you can't, part of living in a free country free-ish country is that you can't exactly arrest anybody when they haven't done anything. And yes, certain things are arrestable offenses, but certain things, even though they might make someone feel intimidated or feel scared, unfortunately, don't rise to the level of, and you see it all the time, especially in DV cases, where you see stalking cases and you're like, well, he, was outside my house every night. He was parked outside my house every night. Creepy, yes. Illegal, no. And that's the problem. It's it, Levy County is under full federal investigation. Good. But yeah, it makes your blood boil, but it's not just this. This is countrywide. This happens to a lot of females, more than males, but stalking behavior. I know this person's stalking me. I know this is this. I know this is this. They're outside my house every night. Every time I go to the grocery store, they're at the same exact grocery store. I went to 2 different grocery stores, one right after the other, and they were at both. It's stalking behavior. It's creepy. It's going to escalate, but rock in a hard place. It's yes, 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 yes. But you're right. You're kind of missing my point where I'm going with this. As a whole, what Jeremy is saying here is what Jeremy said in his original complaint. I very much think is true. Because intimidating and threatening behavior cause plaintiffs fear of death or bodily injury. I completely believe that is true. No, not even trying to downplay that at all. However, there's a problem. There's an issue in this country of what can be seen as harassing or intimidating behavior that can make someone fear for their lives does not necessarily reach the level of, even with a protection order. But here's the thing. The protection order is not, he sued Daniel Owen, the state's attorney, but technically not enforcing the protection order would not be on a prosecutor. It would be on the sheriff's department for not arresting. There's the problem. Yeah, yes, there's my point. Thank you so much for putting it in a way that makes sense. It's not a Jeremy specific to this case issue. It's a countrywide, nationwide problem. And part of it is the fact that we live in a free country. The other part of it is we have people who are downright lazy when it comes to enforcing things. So, it was the prosecutor who said leave it alone, but but when it comes to immunity, I believe that was a setup. And this is why y'all are going to get mad at me, because y'all, this is why you're going to get mad at me, because I disagree with this lawsuit as a whole, but I also think this was a setup. Because if you read the statutes, the prosecutor is not. So here we go. We're going to get into that code. The faith and full credit given to protection orders is the courts and the police. The prosecutor is seen as neither of those, therefore is immune to full faith and credit. There's the problem. There's the problem. Full faith and credit is courts and cops. A prosecutor is seen by the state of Florida as neither one of those. Therein lies the issue. So even though he told them not to enforce it, he was able to hide behind immunity, knowing that Jeremy was going to get mad at him for saying it. It's the cops who need to enforce it or not enforce it. So Jeremy sued the wrong people, in my opinion. If you're going to sue somebody for this, you sued the wrong people. There's the like there's the issue. It's failing to follow federal order does not fall under immunity. Owens and sheriffs are at fault. Not according to the law. Morally, 100% agree. But we go back to this. It's the statutes that deserve it. They hate. The law is the problem. Feelings are valid. They're just not admissible in court. And there is, remember, a long time ago, we had a long talk on this chat or on this channel about the difference between what we feel as morally wrong and ethically wrong and what the statutes say. And unfortunately, that one I think might actually be that one probably a better there's the other problem. However, the statute is on Dan Owen's side. And that's why I knew you guys were going to be pissed at me and y'all were going to put all sorts of freaking opinions in the damn chat. I know it's coming. I knew it was coming. Hence why we started that off with a little monologue that says, like it, that you missed my point. 18 U.S. Code 2265. Here we go. We're gonna go with this. So this is the full faith and credit. This is where the U.S. code takes over. Only applies to the court and the cops, not the prosecutor. The prosecutor is seen as neither the court or the cops. Hence why I think Dan Owen did this. I think Dan Owen is shady as shit based on what I've read. However, playing 3D chess, I think that he did it purposely, knowing that he could hide behind immunity. Like I said, I hate immunity. But I knew this was going to fucking come, and I knew that y'all were going to be pissed off, and you were going to try to say, but federal law. Full faith and credit. Any protection order issued that is consistent with subsection B of this section by the court of one state, Indian tribe, or territory shall be full faith and credit by the court of another state and enforced by the court and law enforcement personnel of the other state, as if it were ordered in the enforcing state or tribe. Court, law enforcement. Prosecutor is neither. Which is why I think this is my personal opinion. I think it was a conjecture, or like it was completely set up. Jeremy was set up. Like, yes, it was a tactic to bait Jeremy. And I know that some of you have a problem with this, and me saying this. I think that this will be used against Jeremy. And I say that in a way because I think this will be dismissed. I hate to say that because I think Jeremy is fucking right. I think that it was shady as shit. I think it was a setup, though, knowing that Jeremy would sue because obviously he feels like his fucking constitutional rights have been, which they have. I think he just sued the wrong person. I think he needed to sue the sheriff's office but I think Dan Owen knew that he was going to be the one who was sued and he could hide behind immunity because full faith and credit only applies. Here's the statute from law.cornell.edu. 18 U.S. Code 2265. Like I said, I had receipts ready. But here's the thing. Here's the thing. Investigating is part of his job. There's the other. prosecutors according to the state of Florida are not seen as a officer of the court. There's the problem. And because the statute, the federal statute does not mention it, it resorts back to state law as far as what is seen as law enforcement by that state. Because technically, as far as the Florida statute does not see it as either. It's a weird loophole. I don't like it, but just because I don't like it doesn't make it like cops have a limited immunity, but cops' immunity is easier to revoke than that doesn't explain why he thought he needed to hide behind it, though, once it's linked to all this, and why would he want to protect Preston Cook? Because I think he's a shitbag. I think he doesn't like Jeremy. And I think he did this to bait. I think somebody said it earlier, to bait Jeremy. And I think, and another person I had a disagreement with me yesterday, and I think they misunderstood me. I think that the What the Hale's Ecosystems end game is to try and get Jeremy labeled as a vexatious litigant. Hear me out on that, because y'all jump to fucking conclusions and let your emotions get all sorts of whack before you even listen. I never said that it would work. I'm just looking at their fucking playbook because it's predictable. Just because when you're watching football, you know what the other team's going to do. You don't think it's going to work, and you know it's a stupid play. But when people are predictable, I believe that they are going to try to use this against him. Like I said, I don't think it's going to work, obviously. I don't think it's right, obviously. However, we've seen that stupid people do stupid stuff every day, all over the world. So before y'all start hating, because y'all listen to half of what I say, but you don't understand the reasons why I say it, and y'all start going, well, Jeremy's not a vexatious litigant. No fucking shit, people. No shit. We know this. It doesn't take a rocket scientist. Would I have filed certain lawsuits that he did? No, but that doesn't make you a vexatious litigant. That just makes you have a difference of opinion. But do I think that is their playbook? Because that is what they've been building to. And that's why they got so pissed off when Jeremy tried to labeled what's her nuts as a fucking vexatious litigant, Lips. Because that's their playbook. And he took a page out of their playbook and they got pissed. Only for her it was applicable. So this is federal. Okay, thank you. No worries, I don't listen to anything. Yeah, it's just because one can analyze and comment does not mean they endorse. Yes, exactly. My God. But I get all the time, like, I'll say it. And even to people who I love dearly and I get along with great, we're like, well, that'll never work. It's like, I'm not telling you what is going to work. I'm telling you what their next play is going to be, because they're predictable as fuck. Bruce, I'm sorry, bro. You are predictable. Your playbook, it's like I have it right here. It's just, like, it's just, and I completely agree. Exactly, right here, Roy. They tried every stupid trick in the book so far, so why wouldn't they double down? And the polyflap thing was like the dead giveaway. Oh, and every single lawsuit and every single motion to dismiss, they always mention the same things. YouTube content, God forbid, fucking YouTube content. They always mention YouTube content and how many lawsuits he files, and that they're frivolous lawsuits. That right there is like the trifecta for, I'm going to try to label you as a vexatious litigant. When everybody does it, it's like the media. You see the same freaking headlines and you see the same taglines in every freaking first words of everybody's reporting and everybody's stories, that they all say the same thing. It's because they're trying to spin a narrative. Same fucking thing. It's not, it's kind of obvious if you pay attention to that specific thing. And because I pay attention to the stupid things people do, I pay attention to patterns. My brain works in patterns. It's ridiculous that people lose their minds when you disagree with anything. Yeah. And the problem is, Double Fan, is I don't necessarily disagree from a moral standpoint. From a moral and ethical standpoint, I think Daniel Owen is a shitbag. To even imply that someone committed perjury without any evidence, to me, is just like, like I just like it's just one of those situations. And I think the immunity statute in Florida is goes way beyond. Angel, you want this?
Yep.
Okay.
I do.
You want to go over there and eat it?
Yep.
Okay. Can I have a kiss? Hugs? Oh, thank you. You're a sweet girl. There you go. I love you. Mom. I disagree from a realistic standpoint of common sense. I don't from a moral and ethical standpoint. Like, I think certain people are on, well, I think certain people on both sides are have shown absolutely shitty behavior. And generally I'm not afraid to call it out like you see it, but a lot of times I just don't like to waste my time with it. But when it comes to the documents, since Daniel Owen is the one whose lawyer wrote this this pretty document we're looking at, I don't yeah, but there's also differences between what you say or what you think in your mind behind closed doors and what you say in an official email that could be part of a FOIA request. There's always when you're acting in an official capacity, you don't, there's certain things you just don't do. In my like personal opinion. Like, there's just certain things. Like, there are certain things that I say on this channel that on my other channel, which is my professional side, where I'm using my college degree, there are certain smart ass remarks, and like, I try to joke and have a good time even when I'm recording videos, but there are just certain things that I don't say because it's not appropriate for the situation. Same thing in his emails. Just because you think he did not have to put the perjury part, he could have left that fucking part out. That part is the part that makes me think he's a shitty human being. He could have left that part out and it was like, yeah, I'm just investigating because that's part of my job. But to put that extra because I think he committed perjury part is like a shitbag human being move. It's, we can all agree to disagree on things, but like other side, we agree to disagree, or lose it at each other. There's people who have rage quit me and will not watch me at all and say I'm the worst person on the fucking planet and I'm this and I'm that and I'm all sorts of fucking names because they don't like that I disagree with Jeremy. But I'm still talking about it. No, I'm talking about it because it's an interesting case. And I'm talking about it because I have a Pacer account and don't need to ask anybody else for documents either. That's kind of fun. It appears that the motion is trying to indicate that the arrest of JC was an example of them enforcing the order, but that arrest did not involve JH, and that there's the implication. So I think this will be dismissed based on what I've read in the case law. Do I think that he is still a shitty human being? Abso-freaking-lutely. But just, once again, just because someone's a grade A grass-fed jerk does not make it illegal. It just makes it crazy. But Mercury squared the lawsuit on Levy County Sheriff's Office accounting, but this had to be done first because Levy County only does what this guy tells him to do. Thank you for that context. I because I have always been under the impression that he sued the wrong person. I did not, and this is where me just paying attention to the documents does not, and not the extra BS, did not realize that they only follow what his situation or what he says, like a cult leader. Over and over, Levy County Sheriff said they only do what he tells them to do. Thank you for that. Reform idea: do away with immunity for all officials. If litigant sues them, they have to put money for bond into being held by third party, basically making the loser pay all costs. Yeah, I do agree with the original, and we had a conversation about, I know that about 125 of you did not see any of my coverage talking about the Hannah Dugan case. Hannah Dugan is a Milwaukee County Circuit Court judge. And that courthouse is part of the reason why it was so damn easy to leave the freaking county or the county of Milwaukee and the state of Wisconsin. But going into that, she is hiding behind immunity as to why she let an undocumented immigrant leave through a jury-only door to try to evade ICE. Whatever you think of our laws in this country, she's hiding behind immunity. But in that case, both the magistrate and the district court judge wrote very lengthy opinions on her motion to dismiss, we got a good history lesson about judicial immunity, where immunity actually came from. The immunity going back to 1607 England, and if Spawn Troopers watching, I know my English law history. I believe it was Cooke, Cooke, 1607, not JC. It was the original immunity was to not allow people who lost in court to sue the judge civilly because you lost. That should be the extent of the immunity, but I believe people have warped the idea of what immunity is. People have not been held accountable for their actions ever. And immunity has become this blown up thing where I can act like an asshole. I can do whatever the fuck I want, and I can hide behind immunity, and I never have to face consequences because no jury or no governor is ever going to take me off of my seat, or that no person who appointed me is ever going to remove me from my seat. It's your coverage of that is absolutely awesome. If you want to see me flip out over immunity, it seems to me that you provide an open, honest context about things and don't let emotion rule you. My dad taught me when I was real little that facts never give two flying fucks about your feelings. So if you make decisions based on emotion, life is going to be hard. And I try not to make decisions based on emotion. Sometimes I do. I'm not going to lie. I'm human. Everybody does. But I learned a long time ago. That's what I was taught from a very, this is fucking English again. Okay, blame the UK. Yep. Yep, pretty much. Spawn showed up. Wait, where'd he go? Did he actually show up, or did I just mention him and that's why you put his link in the Oh, he is here. Hey, Spawn Trooper. How are you? Don't want you're naming me. I'm Welsh. Live in freaking Wales. I don't live in Wales, fuck England. Well, the UK. Yeah, because they're their own entity. They're. I'm playing catch up because of work, but I just want to say that I rage quit so I can come back and rage quit again. It's an art. Yeah, negligence should trump immunity regardless of the situation. I agree. I just think that, and I had a discussion with someone yesterday. My thing, and this could be a lawyer issue. This could be a Randy thing. But my thing is if you had more, wouldn't you want to put that in the original complaint? It was not. So I mean, like this is like I said, this is just my layperson's opinion, and I'm not a lawyer, so I don't know for sure. But I think that I would want to put, you know, well, UK is English, Welsh plus Scottish. Well, here's the thing. All of our since we were technically my state is named after King George. So everything from here generally originated from there. So all of our problems that date back to 1776, you can blame UK for because it's their fault. Need to do away with qualified immunity. Yes, it can be taken for Leos. If they did away with it, they would always be doing the right thing. I don't agree that they'd always be doing the right thing, but I believe that it would be better, it would be better if they would be held accountable. My bet is the case goes forward and Owens gets sanctions for not following federal orders. I'd have to disagree with you, but anything's possible. The reason that I don't think that I think that it will be dismissed or they'll have to file an amended complaint is because of the qualified immunity statute in Florida is so tough to negotiate, and because the federal law never indicates that what a prosecutor is. If a prosecutor is the member of the court, when I had these questions, I went to ChatGPT because I'm like, it doesn't say what a prosecutor is. Is a prosecutor a member of the court? And according to Florida, it told me no. So I couldn't find anything in Florida law. I thought that was Florida. Not me. Florida was bought from Spain. Yeah, a lot of our people don't realize the original 13 colonies were British, but a lot of our territory was bought from other people or other countries. Spawn needs to file a motion to use his immunity. Spawn will never be immune. I don't need witness protection. Oh no. All right. We'll get into more of it later. The plaintiff claims Owens' investigation of the protection order amounted to refusal to enforce. I believe I read this part. Plaintiffs bring 2 claims for relief: failure to give full faith and credit to the protection order under 48 U.S. Code 1983, and 1983 is just civil rights, and 2, violation of due process under 42 U.S. Code 1983. They seek compensatory and punitive damages, attorney's fees, and costs, injunctive relief requiring Mr. Owen to give full faith and credit to valid what is it with people in the last name Owen? Sorry. Ask if prosecutor has immunity if not following federal orders. Well, here's the thing, that the question is, and this is the question for the judge, what does Florida view as, because it's not in the federal statute, therefore it goes back to, if something is not in the federal statute or doesn't define, it goes back to whatever the state law defines that as. And the state law in Florida does not define a prosecutor as a member of the court. Why? I have absolutely no freaking idea. Because it seems logical to me that a prosecutor would be a member of the court. But maybe they do that to keep the judge and the prosecutor separate in criminal cases so that you can't say, well, they're on the same team. Because I do that all the time. I'm like, well, the state and the judge are on the same team. But here, the thing about it is when it's not in a federal statute, it goes back to whatever the state defines it as. Just like the service issues, because the federal law does not define how to serve someone or alternative means of service, it defaults to the state level as what that state defines as alternative service. There's a good example. Because it's not in the federal statute, it defines, that's why they had to follow Wisconsin law for serving Teschendorf, they had to follow Florida law for serving for alternative means of service for whatever his name is, Luthman. So when it's not in the federal statute, it resorts back to whatever the state says. That being said, the federal statute does not define the prosecutorial role. The state does. SAO is the prosecutorial authority between the judiciary and law enforcement, but is clearly an entity of the criminal justice system in Florida. It just seems weird the way it's you know. It just seems weird the way it's worded, and the way it's worded technically does not define his role. So there is no federal law to define his place, if you know what I mean. That's the problem. That's the issue. That would make sense. And that is what I have always thought. But that is not what the federal law says. And that's the federal law doesn't define the prosecutorial role at all. It just says the court and law enforcement. You would think that the prosecutor would fit in one of those two categories, but it doesn't. Because the state of Florida does not define the prosecutor as the court. There's the problem. That's why we say just because yes, there it is. Well, it's like there's there's the problem. Just because we think that something is a certain way, I've always thought that a prosecutor was a member of the court. It kind of made sense, kind of logical. However, we've realized that laws, especially Florida laws, are not always logical. Things that we think seem logical and make common sense are not. And that's where the problem comes in as to what we think is morally and legally right is not always illegal in the eyes of the law. There's the problem we have in this. Yes, can be sued if they violate constitutional rights. However, this is that immunity hurdle is a hard one to get over because of the way the federal statute is worded and the way the state statute is worded, and because of shitty case law. So, Mr. Owen give full faith and credit to valid protection orders from other states and to refrain from investigating the basis for such orders except as permitted by federal law. Although the complaint contains these claims and purports to describe the damages, the allegations plead do not I can't ever pronounce that word. Support either the claims or damages alleged. What would you like, honey? Okay, I have to go grab your proverbial chat pitchforks, grab your emotional support drinks, and I have to go do mama duties. Hi, sweetie. I will be right back. Mama duties need. Alrighty. Did everybody grab their digital tomatoes ready to throw at me? So, what statute? What statute? Because I didn't see it. And I did like an hour and a half of research of just shit that was in this last night. Sorry. It was snack time. Had to cut up an apple. Florida can't follow federal rules and mandates. They shouldn't qualify for federal aid of any kind. Well, from what I could find, the federal statute did not define certain things. The state statutes that I saw did. And the case law that sets precedent for all of this does not. The magistrate can rule any way he sees it, but don't go bonkers if he upholds Owen's motion based on current law and established precedent. I hope his staff can find a loophole. I do too. But this is what thank you, Jeff, for being the voice of reason and common sense in my brain. Because what I'm finding in the law, unless they can find a legal loophole that I cannot find, which they might because they're lawyers, I am not. And I'm just doing internet searches. I don't have Westlaw access or any of that fun shit. However, what I can find is not looking good. So, and the alleged allegations conflict with the reality that the 8th Judicial Circuit State Attorney's Office actually did bring charges against the restraint. I think that's misleading the court a little bit, so it'll be interesting to see Jeremy's response or Randy's response. And this plaintiff's failure to state a claim. God, everybody who ever writes a motion to dismiss against Randy, I swear, with the exception of maybe one, had failure to state a claim because the lawsuit lacks merit and fact in law. To survive a motion to dismiss, a claim must contain sufficient matter to state a claim for relief that's plausible on its face. These two cases, Ashcroft v. Iqbal and Bell Atlantic Court v. Twombly, you freaking heard it 1,000 times. Plausibility requirements require more than a possibility of a defeat. A defendant acted unlawfully. Plaintiff's obligation to provide the grounds of his entitlement to relief require more than labels and conclusions. A formulaic recitation of the elements of a cause of action. Naked assertions devoid further factual enhancement, or threadbare recitals of the elements of a cause of action supported merely by conclusory statements do not suffice. Federal pleading rules require a complaint to provide sufficient notice to a defendant of the causal connection between him and the plaintiff's claim. Conclusory allegations that can be disproven by fact of which the court can take judicial notice and legal conclusions are not accepted as true for the purposes of a motion to dismiss. Here we go. Here's the get your pitchforks ready, because this is where the case law starts to get really fucking shitty. Mr. Owen is entitled to absolute prosecutorial immunity. Is immune from plaintiff's claims that he failed to enforce protection orders. Immunity renders certain public officials completely immune from liability, even when their conduct is wrongful or malicious prosecution. Hart v. Hodges. Let's see. Where's my Hart v. Hodges? Supremacy clause. Obligation of state courts under supremacy clause. Ashcroft v. Iqbal. Imbler v. Pachtman. Okay. I don't have sedition and treason. Okay, that's very different. I can't find. I must have closed it. Shit. I had Hart v. Hodges up. Having absolute immunity in civil damages actions would be of little consequence if it could only be asserted when defendant prosecutor correctly compiled with all of its legal obligations, in which case there would be no claim. As a preliminary matter, the full faith and credit clause does not mandate unquestioning obedience, nor is Section 1983 a strict liability clause. Also, some of these clauses say may, not shall. And that little word, may, is huge. Is huge. Hey, SMN, how are you? As described in section 2 below, it's not likely Mr. Owen's conduct amounted to a constitutional violation. Moreover, a prosecutor is not liable for every allegation that an action was unlawful or taken for a forbidden purpose. Adoption of this construction thus would deprive absolute immunity of its intended effect. I hate Nixon v. Fitzgerald. Ugh. Discussing presidential immunity. In Imbler v. Pachtman, the Supreme Court determined that prosecutors enjoy absolute immunity from Section 1983 cases for activities that are intimately associated with the judicial phase of the criminal process. This stems from a concern that harassment by unfounded litigation could both cause a deflection of the prosecutor's energies from his public duties and lead him to shade his decisions instead of exercising the independence of judgment required by public trust. The 11th Circuit described the evolution of the Supreme Court precedent on prosecutorial immunity, explaining subsequent Supreme Court decisions established outer bounds on what activities qualify for prosecutorial immunity and which individuals it applies. Prosecutorial immunity applies, for instance, to the prosecutor's actions in initiating a prosecution and presenting the state's case. Prosecutors immune for malicious prosecution. Prosecutors are immune for appearances before a court and conduct in the courtroom, including examining witnesses, presenting evidence in support and a search warrant during a probable cause hearing. They're also immune from damages claims alleging from failure to institute a system of information sharing among deputy district attorneys regarding confidential jailhouse informants. 11th Circuit went on to explain circuit precedent. Applying these principles, our circuit has emphasized that a prosecutor enjoys absolute immunity from allegations stemming from the prosecutor's functions as advocate. Such absolute immunity extends to a prosecutor's acts undertaken in preparing for the initiation of judicial proceedings or for trial, and which occur in the course of his role as an advocate for the state. Prosecutors have absolute immunity when filing information without investigation, filing charges without jurisdiction, filing a baseless detainer, offering perjured testimony, suppressing exculpatory evidence, refusing to investigate complaints about the prison system, and threatening further criminal prosecution. The determination of absolute prosecutorial immunity, it hurts. It makes me cringe every time I say that friggin' word. Depends on the nature of the function performed, not whether the prosecutor informed that function incorrectly or even with dishonesty. Thus, absolute immunity renders certain public officials completely immune from liability, even when their conduct is wrongful or malicious prosecution. Plaintiff fails to allege Mr. Owen engaged in functions normally performed by a detective or police officer, that he acted as a witness or spokesperson or as an advisor. Van de Kamp v. Goldstein. Instead, plaintiffs allege without explanation that he failed to enforce the protection orders. Plaintiffs do not explain what action Mr. Owen, the state attorney, could have taken that he did not take to prevent the harm they allege, that third parties violated the protection orders. The common sense answer, and the one within his official prosecutorial capacity, is that Mr. Owen failed to bring charges against the non-parties, a decision for which he is entitled to absolute immunity, and a claim for which plaintiffs lack standing. Prosecutors are absolutely immune from liability under Statute 1983 for their conduct in initiating prosecution and presenting the state's case, insofar that the conduct is intimately associated with the judicial phase of the criminal process. The footnote and allegation is rebutted by facts of which the court may take judicial notice. State v. Preston, Levy County. State v. Preston, Levy County. That one filed April 1/26, 2024, April 5th, 2024. And State v. Cook, July 11th, 2024. Charges brought against the restrained parties for violation of protection orders. Just the case. Oh yeah. It's yeah, he definitely throws them under the bus, which, you know what? I probably, which sucks. Like, which I I don't agree with any of this shit. I'm just reading what the law says and what the case law has proven. I don't agree with any of this. I want to make that very, very, very clear to the people who hate watch and like, oh my God, she's this, she says this, she disagreed with it. No, I don't agree. But sometimes we got to take our emotions out of the situation and go by what the law says. Because regardless of how we feel, the court doesn't give a flying fuck how we feel. The court only cares about what's written in these motions, the case law, and the law. That is all they care about. The the judge could give two flying fucks what I sit here bitching about every day. It doesn't matter how much that you hate them, how much that the court of public opinion disagrees with whatever decisions they made. They do not give a shit. Which sucks in the sense of like, you know, Squid does not agree. I hate immunity. I hate it. I hate it. I hate it. I hate it. Like, I hate it. Uh, oh, thank you, Charlene. I just, I'm kind of like to the breaking point. Like, I'm covering this case because it's interesting to me, and I like when I make decisions on what to talk about and what to cover. It's not because somebody else is doing it or this person is doing this, so I'm going to cover that. Like, I make decisions on what cases to cover on this channel based on what interests me. It's why I'm covering the Hannah Dugan case, because I'm interested in it from a case law perspective, what actually is the fact that she's hiding behind immunity, and she tried to say that the federal government does not have um cannot enforce the laws. It was weird. But also it's my hometown. So like I cover things based on what I am interested in. So I've had a lot of people come at me lately of, one, you're only doing this for money. No, like I don't really give two shits because like I monetize my channel. So everything I do on this channel technically is for ad revenue. Welcome to YouTube. Welcome to YouTube. And I've had people lately go, "You're only covering this because so and so is," or "You're only covering this because," or "You're only talking." No, I'm talking about this because it's fucking interesting. But it's also, you got to lay it out for the blind lady of justice. Public opinion is really starting to lean against immunity. Oh yeah, I fucking hate immunity. Hate it. Hate it. Hate it. It's just one of them situations of like for the longest time, ever since I started covering this case, I've had people, other streamers, and a notable person that I don't talk to anymore, but would go, well, the last 3 years, well, the fucking judge doesn't give two flying fucks about the last 3 years. No one does, except for people on YouTube. The police don't care, the prosecutors don't care, the judge doesn't care, the court system as a whole doesn't care. The court system does not give a rat's ass about how you feel. And the fact that people like like the people that are like, I can't it's just the people that whenever the response goes to, well, the last 3 years. It's like, tell me you don't understand, one, how the court system works, and two, the fact that you can't get out of your own way and talk about anything else and the law and how the law actually works. It Measy, I got it done like 3 weeks ago. I got it done. Yeah, immunity has gone way off the path of its initial intention over decades. And that's one of the reasons that certain topics are super interesting, because it's like, okay, can we use the fact that, like, when people are being brought up on charges, they're like, some people are like, oh, they're weaponizing their political power. It's like, no, they're just finally being held accountable for the shitty behavior for the last 20 years. Like, it's for the first time in decades, people are actually being held accountable for their actions. And now we're all up in arms about certain people being charged with things. It's like, no, how about like the seditious six? Probably Friday, if I stream on Friday or next week, we're going to talk about this seditious six. The video that said from the congressman that said basically telling active duty military that they shouldn't follow orders because they're unlawful. Not one of those people has been able to cite an unlawful order, but I have the sedition. I have the 18 U.S. chapter 115, treason, sedition, and subversive acts, and we're going to compare their own words with the definitions of treason, sedition, rebellion or insurrection, seditious conspiracy, advocating overthrow of the government. We're just going to compare, because that's what we do here. We bring receipts. We don't just use our emotion. We're like, I think this is shitty, but it's also illegal, and this is why, because here's the law. Like, not a lawyer, but it doesn't take an idiot to read a law. So, Squid, people are immune to common sense. Yeah, like, if any of us were in trouble legally, we would thank God for channels like yours. I'm just one of the people who will call it like I see it and ask my parents. Even when I think I disagree with my parents, I'm not afraid to tell them. Like, ask my mother. We didn't get into an argument today, but I was like, listen, you need to do this, because every time this happens, you do the same thing, and that's why people take advantage of you, is because you do the same thing every time. You just complain about it and you don't act. I will act. I tell my parents the same thing. So like, you think I'm like, this is me all the time. Like, yeah. And like, ask my mom. Like, my mom and my dad are both in the chat. So like, you think that I'm like this on the internet. This is me all the time. This is me most days, when I'm passionate about something. We have 435 idiots making the laws in the House and 100 idiots making laws in the Senate. Well, they always add to the laws. They never take anything away. But people are also starting channels so that I don't get as many views. Figure that one out. And I've been told this by multiple people. Make that one make sense. I just find it funny because apparently my success, or whatever you want to call this, makes people angry, which is, hi, love you. Like, all right, so we're gonna hurry up and get through this because we have so many to get through. No, Squid doesn't say rat's ass on her second channel. Yeah, I don't. I said shit one day, and I shit one day, and I apologized. I said shit on my live stream on Sunday, and I apologized. Watched it since it started. Those people are just so interesting and dumb as a stump. It's something to do until I finish. Oh, I'm so sorry, Phil. I hope you finish, and I hope it's the good kind of finish. I hope you are finished. You go on to lead a good rest of your life, long time. It's just, yeah, it's just these freaking things. Immunity. So Burns v. Reed, quoting Imbler v. Pachtman, Hart v. Hodges, a prosecutor enjoys absolute immunity from allegations stemming from the prosecutor's function as advocate. Mr. Owen's charging decisions regarding restraining non-parties were closely associated with the judicial activity of the criminal process, so he is protected by absolute immunity. I understand the email to to whoever in Ohio. However, that can be viewed as an investigation, and his office can do an investigation. There are, in some cities, there are investigators specifically assigned to prosecutors and DA's offices. They can do investigations on cases separate from the police, which is so it is a it is there's no precedent for supporting a state official refusing to avoid a valid out-of-state protection order. Instead, the existing case law shows the opposite. Well, here's the thing. The existing case law shows why absolute immunity, why he can hide behind absolute immunity for these actions. The non enforcement of it and not arresting is on the cops or the sheriff's office in this part, and that's another problem. But to the person who said that he started here because they do everything that the sheriff's office does, everything that Daniel Owen says, makes sense. So that kind of provides a little context, which is, you know. So you prove the truth and talk facts, less views, you lie and deflect hundreds of views. Yeah, make it make sense. So, and I understand everybody's issues. I do, because those issues are my issues too. However, separate what I want to happen and what I think should happen with what the case law kind of says in as far as immunity. There is a big difference. So like I get it. I get why everybody's, like I said, go back to the opening monologue and here we need to go over these. If you're offended, congratulations, you're paying attention. Like, woohoo. Like, I'm proud of you because the rest of us are too. But like, plaintiff fails to state a claim on which relief. Mr. Owen is the wrong defendant. Plaintiff failure to state a claim against Mr. Owen because they fail to describe conduct by Owen that deprived them of any constitutionally protected right. Instead, plaintiff's complaint describes actions and decisions by Levy County Sheriff's Office. Unfortunately, I really hate doing this. I agree. I agree. Yeah, like I said though, Roy, there's a big difference between what is ethically and morally right and what is legally. So other DAs possibly, not saying they could, but possibly could hide behind the same immunity for some of their actions. They just don't because they're better people and they don't do this shit. There's where the things, you know. Yeah. Maybe. But the person who, and I can't remember who said it, so I apologize. The person who said that Jeremy was doing this because he was going to sue them next, but they only listen. So and I kind of see that point in the sense of if he sued them, they could go, well, he told us to. Well, he had immunity. So, but I also will going back to my opinion that this was a fucking setup. Like they did this shit on purpose. Daniel Owen did this shit on purpose, knowing that he could hide behind immunity. Once again, I don't think it's right. I don't think it's morally and ethically right, but it's one of those shitty loopholes that he could hide behind. Tree God. So, yeah. Oh, thanks, Bug Naked. Thanks for standing behind your beliefs, not trying to twist things to fit what you want. Trust me, I wish that I would have read this, and I really wish Jeremy, like, I really wish that people would finally fucking get accountability, and people would stop acting like assholes. And I really wish people would stop acting like assholes, knowing that they could hide behind immunity. This is the problem. This is one of the reasons I hate immunity, because it lets people act like assholes. Knowing they're acting like assholes, making a mistake and being able to hide behind immunity because, oh shit, I messed up. I'm sorry. I didn't mean to. Totally different situation than being malicious. I believe he was malicious. But it's sad that the case law says that malicious behavior is still covered by immunity. It drives me nuts. It makes my blood pressure rise just thinking about it. Like, it makes my blood pressure just, like, oh, I think he knew he should. I think he knew he should. But there's also a thing in the law, in the statute, the Florida statute, and I can't remember what statute it was right now. I have to look at my notes. It's Florida statute 4450. Wait. I'm looking through my notes. And I have so much shit written down, whether it be from what I typed, what I was talking with ChatGPT about finding the case law for me. Because ChatGPT is great for like, hey, I need this. Instead of going into Google, I type the case law into ChatGPT and have it find a link. Because it saves hours on searching time, and it's great. But like, it's just, it's one of those like weird sets of, yeah, it's gonna suck. All right. So another thing that I was thinking about, and that I go to, oh yes, that's why I use it to find resources, and then I do this. Like the 1983 Civil Action for Deprivation of Rights. I have it say, hey, find me a link for this, because it's so much easier than trying to search for it on Google and click link after link, but you actually click the links. Like, you know, like you actually, it happens all the time. I use it on my new channel for, hey, find me 5 articles relating to standing, balance, and cognition. And then you click the link and you read the article to make sure that the article has something to do with what you're talking about. But it's so much easier than trying to search on PubMed and click everything, that it gives you 5, 10, 15, 20, whatever you ask it for. And then you have a narrowed down selection instead of going on PubMed where you have thousands of articles. Because I say, and I need articles from 2020 to 2025, meta-analysis of standing, balance, and cognition. Find me a 5 articles that relate to this. And you go through and you, obviously you read them, but it's so much easier than trying to click on PubMed, and it's just so much easier. Because then it'll give me, I have it post the abstract too, so I can read the abstract without clicking on the link. And it's like, oh, that abstract is cool. That article may work. Click on the article. It saves time. But of course, you read the damn, you don't use AI for what lawyers are getting in trouble for using AI. Write me a document. I want 10 case law or 10 pieces of case law that relate to prosecutorial immunity, and then just throw them in there and not actually check your case law. No, that's not how you're supposed to use it. Yes. Good old boys club. Dan Owens, Levy County courts and cops had people talking to them about how much of an asshole JH was. Why would they believe their dear old friend, aka the Meeks and others? Like I said, I used to live in a town of less than 3,000 people. I get it. But he just threw the Levy County Sheriff's Office under the bus. But it's kind of, I kind of agree. They alleged they presented the protection orders to the Levy County Sheriff's Office requesting enforcement. November 20th, 2023, Williamson, deputy number 710 of the Levy County Sheriff's Office, created a police report for documentation only. While it might have been inferred that the Sheriff's Office did not act to enforce the protection order thereafter Mr. Owen's advice, a fact plaintiffs have not alleged. Levy County judicial records demonstrate to the contrary as cited above. Even if Sheriff's Office did not choose to act, however, Mr. Owen is not an agent or a representative of the Sheriff's Office or vice versa. This is the technicality, because he this is the technicality, especially in small towns. Mr. Owen nor did Mr. Owen direct or have authority to direct the Sheriff's Office. Direct, possibly, but he didn't have authority. So they can go, well, we were just following. It's that blame game. Well, we were just following what he told us. Well, I didn't tell them anything because I don't have the power. It's that who can throw who under the bus. Mr. Owen is simply not the proper party against whom to bring the claims because Section 1983 requires personal involvement in the constitutional violation. 42 U.S. Code 1983, every person who subjects or caused to be subjected. See also Monell v. Department of Social Services of New York, 1978. Plaintiffs fail to state a claim, the court should dismiss. Here's where it gets interesting. But it also says he's acting as an advisor, which breaks his immunity. That might be, but I just think there's like 30 years of fucked up case law. I just think there's 30 years of fucked up case law. Mr. Owen's email is not actionable under 1983. This is what I had a big old problem with. The extent the plaintiff's claim is premised on legal advice Mr. Owen purportedly gave to Levy County Sheriff's Office on whether to enforce the protection order. They fail to state a claim because Mr. Owen's email contains no legal advice or even a directive. That's the technicality. And this is where words matter. And it sucks. And I hate it. But he might be right. I hate it. I'm not happy saying it, by the way. Like, totally not happy saying it. He needed to clarify his statement when asked on multiple occasions unless he sent multiple emails to them requesting their stand down. And like I said, the court is only going to go by what's in the motions. So that's part of the reason that I only look at the documents and I don't really pay attention to certain people's live streams or this person showed this document or whatever, because the court is only going to go by what is contained in these documents. With that being said, I have not seen anything else in these documents such as this. It's one of those weird, like, you can't, this is one of the reasons on this channel that we only go by what we see, not by what we hear. Because of the situation of, well, I have all these emails, or I have this, or I heard this, or I heard this, but the judge didn't. That's what makes it so hard. The judge didn't. The judge didn't see that. The judge, unless you put it in the initial complaint, which Randy may not have, because we read the initial complaint here. Yeah. Mr. Owen's email is incorporated as an attachment to the complaint. Exhibit 3. While one of the exceptions to absolute immunity involved legal advice provided to police, the circumstances here are incomparable. Burns v. Reed, it's another one of those Supreme Court cases. In Burns, the Supreme Court determined a prosecutor was not immune where he advised police that hypnosis could be used during suspect questioning. Unlike the prosecutor in Burns, Mr. Owen's email gives no advice at all. It suggests no action. It gives no direction. It clearly requests more information. Plaintiffs failed to allege Mr. Owen gave any advice, made any other statement outside of the email, or took other action to direct law enforcement investigation. Jack's Crab Shack v. Cook, 11th Circuit 2022. Finding prosecutors entitled to absolute immunity where plaintiffs failed to plausibly allege that prosecutors directed an illegal raid, insisted that the officers include the fabricated evidence in the warrant affidavit, and acted in their investigative capacities. Given that the protection orders were in fact later enforced by the Levy County Sheriff's Office when plaintiff reported violations and charges brought by the 8th Judicial Circuit State's Attorney's Office, the inference cannot be reasonably or plausibly made that any such advice was given. Plaintiffs failed to state a claim. And here's the thing. There could be some shit that he just didn't write down. There could be some shit that he just did not write down. So, what statute? What statute? When people, I love when you guys say I looked it up or I saw. Where? Because as much as I like you guys, I don't believe things. You can ask Spawn, you can ask Musi. Whenever they tell me stuff, I'm like, show me. Show me. Most of the time it's in the form of a screenshot because they figured it out by now. But like it's one of the situations of like when you say I looked it up or I found it, please tell me where so I can see it too. Because I am open to changing my opinion on things. Squid believes nothing. She doesn't even believe I exist. No offense, but people lie. And on YouTube, people lie a lot. I've been lied to a lot by people I considered very good acquaintances. And now those people talk shit about me consistently. So I don't believe shit unless I see it. Screenshots, statute numbers, page numbers in a book. It's no offense to anybody. It's just I don't believe my parents unless I see something. Like failure to state a claim under 2265, that's the full faith and credit. Plaintiff's protection order states that it must be given full faith and credit pursuant to Violence Against Women Act, 18 U.S. Code 2265. Under 2265, any protection order is issued that is consistent with subsection B of this section. The court of one state shall be accorded full faith and credit by the court of another state and enforced by the court and law enforcement personnel of the other state, which to initially makes sense. And that's what I see everybody citing. And honestly, that's what I thought too. True Squid is why I say to myself, yeah, pretty much. Yes, Squid is like Missouri. Show me. And that's when I ask the evidence, it's not that I don't believe, it's trust but verify. Like all those people, no offense, who told me that people were finding case law that you can serve someone by email in Florida. Well, it turns out all of the case law that those people were finding were with corporations, not individuals. So, sounded great. Still not true. It died? Can you hand me the charger? Hey, boo. Right there. Yeah. She hands me the cord. She's like a puppy playing a game. She'll get close to you enough where you can grab it, and then she'll take it away from you. Angel. Let go, please. You're not going to get it charged. No pad for you, then. You're not going to get your pad for a week. I will pack this up, and we will give it to Grandpa as a Christmas gift. There you go. Oh. Hey, Big Tip Dog. Yes, people are also wrong a lot. How are you, Big Tip Dog? It's good to see you. Yes, people are also wrong a lot. Well, I think of it this way. I don't think a lot of people are wrong intentionally. They hear it from someone that they believe, and then they pass it on, and then the telephone game. I use the thing of when when Bubbles got a gifted membership to my channel. He was not in the chat at the time, but it got back to certain other people, where it was told to certain other people that he was in my chat when he got it. No, he wasn't. And it was like, it's something like that. You got your pad. Okay, there you go. So it's just, I think the telephone game has a lot to do with it. And it's just, I annoyed my parents. I'm pretty sure they regret teaching me the words why, technically, and because. So yeah, it's often unintentional. Sometimes it is. Sometimes people intentionally mislead you. I try not to be that person. It's why I come with receipts all the time, because I try not to be the person. I am not perfect by any means. I understand sometimes I say stuff and it turns out to be wrong information, but I try when I'm called out to, because calling out is the only way I'm going to remember to change it. But this is what I feel like people cite, and then they kind of leave it at that. Which if this was all of the statute, that would be great. That would be great. But unfortunately, it's not. Mr. Owen is neither a court nor law enforcement personnel. I promise I didn't read this. I promise I didn't read this. I did a word search and looked at the statutes. I just typed U.S. code into the search and looked it up wherever it was, and then just copied those statutes to look. But Mr. Owen is neither a court nor law enforcement personnel, which was my whole point. It's shitty. I hate it. I don't agree with it. But in Florida, man. I'm driving and listening to my comments, and I make sense. Oh, be safe. Be safe. But it's good to see you. Accordingly, he had no obligation under federal law to give full faith and credit to the protection orders. That was my whole point going back to the beginning of the stream. I don't agree with it. But, and we all think of a prosecutor, as it's court personnel. I don't like it. I don't like it at all. But I don't like it at all. But yeah. Under 18 U.S. Code 2265, only those protection orders issued by a court that has jurisdiction over the parties and matter under the law of such state, and reasonable notice and opportunity to be heard given to the person against whom the order is sought, are entitled to full faith and credit. The Florida Enforcement of Foreign Judgments Act must also be considered. A foreign order, and here's the problem. Here's the problem. A foreign order may be challenged for lack of jurisdiction or extrinsic fraud. That was the statute that I deleted there, that I closed the tab. I had it open last night, but I was doing stuff for some family members this morning, so I had too many tabs open and accidentally closed. It sucks. It sucks. I don't like it. I don't agree with it. But maybe. But also, there's different statutes and different interpretations of things based on different organizations. And the bar might see you as a member of the court, but once again, the law does not. And but the bar is more of an ethical issue. It died again, yes, because you didn't leave it on the charger. We gotta learn. Oh, get your magnet tiles. Oh, get your tiles, dude. So there's the bar generally deals with more of a, it's hard to explain the difference, but the bar and Florida statutes of what court personnel is are able to be different. And it's not always going to be what we like. There you go, beautiful. It's this is why I'm going to keep my channel free of these court cases. I'd rather grow slow than deal with people throwing tomatoes at me. I hate tomatoes. That's why my other channel, I started my other channel because that is my career. That is what I went to college for. And what I went to college for, although controversial in itself, is a lot less, yeah. So, but but here's the issue. Mr. Owen's questioning of the restrained parties ties to Ohio and his questioning of whether the plaintiff lied in their position was entirely proper under state and federal law. I don't agree with it. I don't like it. I don't like it. This is where my moral and ethical and my moral outrage of why someone can act so shitty and this is where like my ethics and the law fucking yeah. Like same thing goes in medicine. It's one of the reasons that malpractice is so hard to prove, because what we think of as morally and ethically wrong is not always legally wrong. It sucks, but such is life. Life isn't always fair. My other channel is I should pin it to the top of the chat, shouldn't I? My other channel is no court cases at all. We are currently in the second week of a 5-week series on fall prevention. So if one of you guys could post my link, and that way I can pin it to the top of the chat. There we go. Uncle Buck did. I know most of you guys have been. I just haven't been pinning it. There we go. I pinned it to the top of the channel, or top of the chat. So we are just under 200 subscribers over there, which is cool because I want that channel to be, if you have YouTube dreams, like this channel was, to be perfectly honest with you, this channel was an April Fool's joke that just sort of worked. I started it as like this isn't going to go anywhere. This is going to be like whatever. And then it kind of like, it happened. That being said, that one is my college degree, my baby, using my certifications and my professional knowledge. And I want that channel, if you were to have dreams, I want that channel to be bigger than this one. Because that one is like, this one matters too. Do not get me wrong. I'm not trying to say anything, but if I had to pick which one I would ever want to, in my dreams, get that 100,000 subscriber plaque, that play button, it would be that one. I was Freckle Ginger. Thanks for the $2 super chat. I was mean to 2 OTs today, and I'm not sorry. Was it about billing, or did you go to OT today? So, well, the problem is these statutes use the word may, not shall. They may enforce, not shall enforce. It's why when you read shit, every word matters. Occupational therapy. So, oh shit, 200? Sweet. I've currently recorded a video today doing balance exercises. So it should be a shit show. It is my first one where I recorded it in my kitchen. It's gonna be a shit show. It's gonna be funny, but it's gonna be a shit show. Uh, oh, that's wild. I'm literally heading into my neuro PT right now, also recovering from a shattered leg. Ouch. I had a Chiari decompression surgery back in 2020. Um, so I'm an OTA by practice, but I never want to work in a hospital again. I worked with a lot of stroke patients and neuro patients, and now I have a corrective exercise certification. I would love to start a business someday working with those people who are too high level for PT and OT, but not safe enough to be on their own, say at a gym or with ADLs and stuff like that. But they have the potential, but they need that. I also want to work with injured athletes who are like too high level for PT, but too low level to do their sport. So there's that. But, you know, no problem. I get it too. uh, so I don't like this, but unfortunately, the statutes kind of agree only because of the wording. If they were worded different and said shall enforce, or Florida statutes clearly defined a prosecutor as a member of the court, because honestly, it doesn't matter what the bar thinks, which is sad. But in the sense of what the statute says, it doesn't take into account what the bar says. It sucks, but it sucks. Like I can't like I knew this was gonna make y'all angry because it makes me angry too. But it no liberty or property interest in protection orders. This one, plaintiffs failed to establish a deprivation of a liberty interest protected by a due process clause. 14th Amendment provides that a state government may not deprive any person of life, liberty, property without due process of law. To establish a procedural due process claim, a plaintiff must first show cause the deprivation of a liberty interest protected by the due process clause. The Supreme Court has considered whether a party may assert a claim for deprivation of due process upon a state's failure to protect liberty or property interest. Harder v. Hunter, citing Town of Castle Rock. Court held no such interest existed. A benefit is not protected entitlement if government officials may grant or deny it in their discretion. 11th Circuit explained Supreme Court of Florida has held there is not now, nor has there ever been, any common law duty for a governmental entity to enforce the law for the benefit of an individual or a specific group of individuals. Because plaintiffs do not have a constitutionally protected property or liberty interest at stake, they failed to state a due process claim under 42 U.S. Code in 1883. This is where it's like, wouldn't you be property? Yeah, maybe. It's all about the way things are worded. It's all about the way things are worded, and they are just, if they are worded weird, loopholes exist. Failure to establish causation. Plaintiff's lawsuit fails because none of the alleged harm can reasonably or logically be connected to Mr. Owen's conduct. That's just bullshit. An 1983 claim requires proof of an affirmative causal connection between the defendant's acts or omissions and the alleged constitutional deprivation. The overarching rule is that where a deliberative, autonomous decision maker stands between a defendant's actions and the plaintiff's injuries, the defendant's actions cannot be the cause of the plaintiff's injury under 1983. Dixon v. Burke County. Is that Georgia? Dixon v. Burke County? Plaintiffs count 1 claims as a direct and proximate result of defendant's failure to enforce the protective orders. Plaintiffs suffered continuous harm to each plaintiff victim's sense of safety and well-being as a direct result of defendant's failure to enforce protection orders, including without limitation physical harm, emotional and psychological harm, fear of death. We've read this. Impact on plaintiffs' daily lives, and I believe all this. Great financial harm. The harm plaintiffs allege was caused exclusively by the non-parties, Preston and Cook. He throws Preston and Cook under the bus. They got on to allege Preston and Cook enlisted others in a civil conspiracy to harm Hales as a result of Preston and Cook being emboldened by defendants. See, I don't think that this is required to be mentioned at all. Plaintiffs do not allege Mr. Owen had any connection to the non-parties, that the non-parties were aware of Mr. Owen's investigation of the protection orders or any other circumstances that might link Mr. Owen's email to the harm alleged. Plaintiff damages were obviously the result of third-party decisions entirely unrelated to Owen's email. I don't know if I would buy that one, but and I do not once again, I agree with the sentiment of the entire chat. I'm just saying this is going to be a hard the immunity based on the way the laws are written is going to be a hard hill to climb. And I hope I'm wrong because freaking Daniel Owen, like I said, couldn't pick the man out of a lineup, but he sounds like a very shitty human being. It's not the email that was sent that I have a problem with. Okay, you have the right to investigate. You want to investigate. It was the way he said things and because I think he committed perjury. You could have left that shit out and still got your point across. If people use that extra like, yeah, and it's my mouse. Sorry, my brain needs something to focus on so I cannot get confused on where I'm at. Plaintiff claimed Mr. Owen's failure to enforce order or deprived a protected liberty interest without constitutionally adequate process. As a starting matter, nothing in the language of due process clause itself requires the state to protect the life, liberty, and property of its citizens against invasions by private actors. Oh, Winnebago County, it's a Wisconsin case, I think. Nor does the history support such expansive reading into the constitutional text. See also Bauer as next friend of E.B. v. Cronister, finding sheriff's office did not violate due process by failing to arrest a restrained party. Plaintiff's claims fail because Mr. Owen was not required to protect plaintiffs from the vaguely alleged private actor or conduct by Preston and Cook. Further, in American jurisprudence, private citizen lacks a judicially cognizable interest in the prosecution or non-prosecution of another. Mr. Owen is also not liable for failing to prosecute. Failing to prosecute is where he does hide behind immunity, and he can hide behind immunity easily. The only two circumstances the government's failure to protect might constitute a violation of the due process clause are if that failure was arbitrary or conscience shocking in a constitutional sense, or two, if the plaintiffs possess a property interest in enforcement of a restraining order. Gonzalez, explaining the federal constitution standard, but concluding that Colorado law did not create a property interest in the enforcement of plaintiff's restraining order. Florida law does not create property interest in enforcement of a restraining order because Florida's restraining order statute gives prosecutors discretion to prosecute the violation. 741.3098 Florida statutes, the state attorney may prosecute it as a criminal violation under 741.31. Footnote, although decisions of other district courts are not binding, they may be cited as persuasive authority. Although a district court would not be bound to follow any other district court's determinations, a decision would have significant persuasive effects. Nor was Mr. Owen's conduct arbitrary or conscience shocking. The shock of the conscience test is to be narrowly interpreted and applied. Supreme Court has repeatedly emphasized that only the most egregious official conduct can be said to be arbitrary in the constitutional sense. Reiterating that the shocked the conscience was so brutal and offensive that it did not comport with traditional ideas of fair play and decency. Would violate the substantive due process. U.S.C. Salerno, so-called substantive due process prevents the government from engaging in conduct that shocks the conscience or interferes with rights implicit in the concept of ordered liberty. Historically, this guarantee of due process has been applied to deliberate decisions of government officials to deprive a person's life, liberty, or property, Ordinary negligence does not shock the conscience. Ay, ay, ay. Hey to all the lurkers checking in. This is just, I just can't. Oh my goodness. I don't agree with what my opinions are. Let's put it that way. My opinions based on what I'm reading, case law, and what I did my research on are not matching up with my ethical and moral opinions of what I think should happen. That is where telling and only going on the facts is very freaking difficult because my brain wants to be like, this dude's a shitbag. He should be held accountable and stop hiding behind immunity for shitty behavior. However, that's not what the law says. And until we tell our judicial system or our congressmen to get rid of immunity or limit the scope of immunity, this shit's going to keep happening. No jurisdiction to grant injunctive relief for unrelated protection orders by unknown parties. Plaintiffs purport to seek injunctive relief for other entirely unrelated protective orders from unknown states, protecting unknown parties from unknown restrained parties. Federal jurisdiction is limited to actual cases or controversies under Article 3 of the Constitution. To establish a case or controversy, a plaintiff must have standing to bring a claim. Plaintiff must show standing for each claim he seeks to press for each form of relief sought. Davis v. Federal Election Commission, quoted authority omitted. A plaintiff demanding declaratory or injunctive relief must show a real and immediate threat of future injury. Stop. And sufficient likelihood that he will be affected by the alleged unlawful conduct in the future. God, I hope this never happens. Plaintiffs requested relief amounts to a request that the court require Mr. Owen to follow the law. An injunction requiring a party to obey the law, an obey the law injunction is unenforceable. SEC v. Graham. And that's another case I looked up and was reading last night, but I didn't make it through enough to describe what it was to you guys. Because the SEC just confuses me on all laws about the SEC just jumble my brain and confuse the hell out of me. Further, all of plaintiff allegations are about past events. They did not allege facts showing any serious risk of continuing or future harm. I'm interested to see what Randy's response is going to be like to this because I'm just interested. How are you? What? Now you're feeling how I felt when we saw the motion from Stupid Dave. No, I felt when we saw that motion from Stupid Dave. I felt that same way too, but I knew that was going to be like that order was not going to be taken seriously by the judge, or I believe that order won't be taken seriously. This one, unfortunately, I believe has more qualified immunity. Here we go with that freaking word again. Even if plaintiffs could state a cause of action for the conduct they allege, Mr. Owen is at the very least entitled to qualified immunity. Government officials performing discretionary functions are generally shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights, of which a reasonable person would have known. Plaintiffs bear the burden of showing that the legal norms are allegedly violated by the defendant were clearly established at the time of the challenged actions. The law clearly prescribed the actions of the defendant to satisfy their burden requires more than making general conclusory allegations of a constitutional violation or by stating broad legal truisms. As the 11th Circuit has repeatedly stated, plaintiffs must prove the existence of a clear, factually defined, well-recognized right of which a reasonable officer should have known. Our cases establish that the right of the official is alleged to have violated must be clearly established in a more particularized and hence more relevant sense. The contours of the right must be sufficiently clear that a reasonable official would understand what he is doing violates that right. The qualified immunity defense provides ample protection to all but the plainly incompetent or those who knowingly violate the law. Well, here's the thing. Is Daniel Owen competent? Oh, boy. Lawyers writing laws and legislation is the issue, lost touch with the common person. I just can't sometimes. You ever look at shit and you're just like, I just can't. Like, I don't want to agree with it. I don't. But it's the that's not what Florida law says. And everything I've read, common sense would tell you that they're an officer of the court. But it's not about what common here's the problem. Here's the problem. Laws are not about what common sense would tell you. Because when laws are written, nobody uses fucking common sense. Once again, like, I don't want to agree with this. But everything that I can find and what I've read looking in the last couple of days of the statutes in Florida and compared to what the federal statutes say, I cannot find anything that says he is an officer of the court. Florida law does not define a prosecutor as an officer of the court, and the federal statute does not make any mention of a prosecutor. They just say court and law enforcement. Therefore, the middleman, the prosecutor, would defer back to what Florida law covers. And Florida law defines them as not an officer of the court. I make it make sense because it doesn't. However, I it Florida law. Florida law does not define a prosecutor as a member of the court. I cannot find any statute that says that in Florida they are a member, they are a officer of the court. I know to the common sense mind, it does not make sense. You would think lawyer, officer of the court, works in the court. Make it make sense. I know it doesn't, and I know it's frustrating. Grab those. Oh, yeah, a bad law, unfortunately, is still the law. But here's the thing. We can't get upset with the judges for enforcing the law. We have to go to the legislative branch and tell them to change the freaking law. And that's what I think is missing. We don't advocate enough as a people, as a society. We don't advocate enough. We're supposed to send our representatives to DC or to the capital, your state capital, and they're supposed to represent you. They don't. We need to get comfortable with calling these people on the phone and letting them know how much they suck. I don't suggest using those exact words because they like to play victim a lot. However, I suggest calling your congressman, your state officials, and letting them know that you're unhappy with certain laws. If you live in Florida, call your state legislature and state congressman or whatever you call them in your state, and let them know that their laws suck and that they need to clearly establish this and fix the situation. And then that's what I'm really, really hoping that Jeremy will do with this whole shit show of a situation, is that he will use his position to there's not, but he has the right to investigate. As the prosecutor, he does have the right to investigate. However, his words were not what he said behind closed doors or not in an email could completely be Hey, I needed a break and I yeeted myself. Chapter 27 defines officer or SAO responsibility. It's so, like, I don't agree with any of this. I don't agree with people not being officers of the court, but I yeeted myself. Yeah. Well, here's the thing. The case law that is being cited by both attorneys do not, from what I can read, do not establish a prosecutor as a member of the court either. And Florida law says that they're not a member of the court. Therefore, unless Randy can cite some case law that says they are, Florida law, this is Florida law. I don't agree with it. I think it's a shitty thing, but I don't have the power to change the law. I can sit here and bitch about it, but, you know, it was not unreasonable for Mr. Owen to believe that he could assess out-of-state protection orders for issues under Article 5 for the Constitution, 28 U.S. Code 1738, assess the Ohio court's personal jurisdiction over the Florida residents under 18 U.S. Code 2265, and assess the orders for extrinsic fraud under the Florida. This is the problem. This right here. The Florida Enforcement of Foreign Judgments Act. That right there is what I don't think a lot of other states have. That right there is an extra piece of legislation that, yeah, he is entitled to qualified immunity for his investigation. Plaintiff lacks arguable merit in fact and law. All Rule 15a permits an amendment once a matter of course. It does not require the court to allow amendment where a suit is I hate that they meant this is where I think that people are going to use this against him, because they all seem to be using the same words. This is the only case against him. He should not be using the word frivolous. Like, this is the only, yeah, like, I think that this was a setup. I think he knew that he could do this, be an asshole to Jeremy, and hide behind immunity. I think he did this on purpose, knowing that he could hide behind immunity. Once again, shitty behavior. What I believe is a shitty human being. Shitbag of a prosecutor. However, grade A asshole is not, it's not illegal to be an asshole. Oh, it sucks. It sucks. But being an asshole and like I feel like he knew that he was going to get sued and that he could hide behind immunity. So I think he just skirted that line to be an asshole without being a chargeable asshole, if that makes sense. And hey Joe. But this is where I think that they call me a conspiracy theorist, but I think he's been keeping an eye on everything, because this sounds very anti what the Hale ecosystem-esque. Even where plaintiffs proceeding pro se and the court required to construe plaintiff's claim liberally, the court would still be warranted in dismissing with prejudice if amendment would be futile, because amendment is unnecessary if the claim is patently frivolous. Oh, plaintiffs here, though, are represented by counsel. The court should hold plaintiff to the strict pleading standards under federal rules under Iqbal and Twombly, and no claims based on the facts alleged would survive a motion to dismiss. The court should dismiss with prejudice. All right. Absolute immunity, failure to state a claim, qualified immunity, and words that I all hate. Like, yeah. His attorney and Randy met for a conference. I wish I was a fly on the wall. Like, Oz, the immunity was a topic. Yeah, I just can't. Like, this was written by Anthony Dean Johnson, a senior assistant attorney general, by the way. Like I said, I don't agree with much of that. There's probably one part where I'm like, I think that's plausible. But the law but I don't there's a lot of laws in this country that I don't like. So, you know, Debbie Baker, thanks for the $10 super sticker. You are awesome. I hope you are doing well. And hugs, Debbie Baker. You know we love you here, right? All right. So, we have a couple of things in federal 2 to get through, and I call that federal 1. So if anybody or I call that federal 3, so if I don't know if anybody else does, but if you hear me say federal 3, it's the Dan Owen or Daniel or whatever the frick his name is. I couldn't pick the man out of a lineup, like, you know. All right, so this was filed yesterday or today? Yesterday. Motion for Rule 11 sanctions requesting the withdrawal of challenges to personal jurisdiction or defects in service. Hey, Kathy. Yeah, it's without a doubt an uphill battle with Owens having the high ground. It sucks. It sucks. Elephant Shoe LLC. Yeah, we all know this. Pursuant to Rule 11 of FRCP, hereby respectfully move this court for an order requiring defendant Teschendorf to withdraw any challenge to personal jurisdiction or defects in service, and for appropriate sanctions. Motion for Rule 11 sanctions arises from Teschendorf improper attempts to challenge this court's personal jurisdiction after having already submitted to the court's jurisdiction by filing a motion to dismiss on the merits. Yeah, that was kind of interesting. I didn't catch that right away, but oh, that explains a lot. Good old James Owens. Oh, yep, that explains so much. Thanks, Sharon. Thanks for that piece of information. Oh, Sharon, did you hear Jumpsuit Pablo? If you do not know who Jumpsuit Pablo is, go follow his channel. He has a recording of Sarah Boone's jail calls, and he's been going over those on his channel. And one of the titles of his video, I'm not going to give the video away, but title of his video was Sarah Boone cries after being attacked by inmates. You know? Despite labeling the filing as special appearance, Teschendorf's substantive challenge to the merits of the complaint constitutes a general appearance as a matter of law, and thereby waiving any objections to personal jurisdiction or service defects. On October 25th, this court ordered service by publication after finding that Teschendorf was evading service of process. Despite the court's order for service by publication, Teschendorf filed a motion to dismiss addressing the merits of plaintiff's complaint. In that motion, Teschendorf improperly labeled the filing as a special appearance and not a general appearance, while simultaneously challenging the substantive claims or allegations of the complaint. You saw it? Oh my god, it was good. Teschendorf continues to maintain objections to this court's personal jurisdiction and the sufficiency of service of process, despite having waived such objections by addressing the merits of the case. And Debbie Baker, thank you for the $20 super sticker. You are awesome. Cookies are open. Squid Procure your past 2 hours. Yeah, and I'm hoping to get through these relatively quickly because these are short. Legal argument, Teschendorf waived challenges to personal jurisdiction and service by filing a motion on the merits. Ooh, this is where the law gets tricky. Under FRCP 12H, a party waives any defense related to personal jurisdiction or sufficiency of service of process by omitting it from a motion or by failing to make it by motion or include in a responsive pleading. When a defendant files a motion to dismiss that addresses the merits of a complaint, regardless of how the defendant labels that appearance, the defendant makes a general appearance that waives any objections to personal jurisdiction or service defects. The distinction between a special appearance and a general appearance is determined by the substance of the motion filed, not by the label attached to it. A special appearance is strictly limited to challenging the court's jurisdiction over the defendant. When a defendant files a motion addressing the merits of the complaint, such a motion to dismiss for failure to state a claim, it constitutes a general appearance. Teschendorf's continued jurisdictional challenge violate Rule 11. FRCP 11B requires that all legal contentions presented to court may be warranted by existing law or non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. By continuing to challenge this court's personal jurisdiction after having made a general appearance through a motion to dismiss on the merits, Teschendorf violated Rule 11. Teschendorf's attempt to circumvent the established legal principle that addressing the merits of a case constitutes a general appearance by simply labeling the filing as special appearance is not warranted by existing law. This tactic is particularly egregious given that the court had already ordered service by publication due to Teschendorf's evasion of service. U.S.C. Federal Rules of Civil Procedure 4 establishes the requirements for service of process and its relationship to personal jurisdiction. Once Teschendorf filed a motion addressing the merits of the complaint, any objections to the methods of service were waived, regardless of how Teschendorf characterized the appearance. Teschendorf continued assertions of challenges to personal jurisdictions and service defects. After having made general appearance through a motion to dismiss on the merits, violates Rule 11 and wastes judicial resources. That's all these people know how to do. These challenges are not warranted by existing law and appear to designed to delay proceedings and increase litigation costs. Shocker. Wherefore, this plaintiff respectfully requests that this court order Teschendorf to withdraw all challenges to this court's personal jurisdiction and any objections to service of process. Impose appropriate sanctions pursuant to Rule 11 of FRCP. Award plaintiff reasonable attorney's fees incurred by bringing this motion and grant such other relief as this court deems. I think he'll get that because that's not that's pretty like cut and dry and clear, kind of obvious. And Debbie Baker, thank you for the 10 gifted Squid Pro Club memberships. You are awesome. You are awesome. Let's see, anybody interesting on that one? Debbie Brown, Jill McCann, Betty O, Just Mandy, Tug Simp. I did it again. One freaking button. This button right here. That button right by my thumb is the back button. All it takes is for my hand to just slip. And Angel, Ella, you can get your pad. Okay, get it. No, okay. Oh. All right, we have one more motion that's only 2 pages, but I have to plug in my phone because it's dying here. Don't hit the big red button. Well, I'm not going to do that. That I didn't do, but I have to open up this motion because it's the only one I didn't have open on my computer. Is too many. I'm not like the expert with buttons. I'm not pressing them on purpose. I'm pressing them on accident. Share screen. 142. And this is another quick one. It's only 5. Change the button assignment? No, I like that assignment. I like that assignment when my hand's not tired. Because I've been on my computer a lot today. So, according to my calendar, the Luthman service deadline was tomorrow, the 25th. So, Randy got his motion in on time because this was filed today. Yeet. I love I'm not the only one who presses the back button and wonders what happened. I've done it twice now. Twice. All right. So this is a motion for extension of time to serve Luthman. Good job, Randy, for getting it in on time. I know he's got a lot going on, but the judge was not happy and not going to let it go if he did not get this motion in on time. In support of this motion, plaintiff states, April 28th, plaintiff filed first amended complaint. naming Luthman as a defendant. FRCP 4M, service of process, was initially due July 28th. October 30th, court granted plaintiff request for an extension, extending the deadline to November 25th, which is tomorrow. At all times, plaintiff had made diligent efforts to serve defendant Luthman, as evidenced by multiple service attempts at various addresses between May 2025 to date. See Exhibit 1. Defendant Luthman is actively evading service, is exemplified by his email dated August 17th, which he explicitly rejected service attempts and stated he does not accept service via email. And Lisbeth, thanks for the 10 pounds, just because you made me giggle. Thanks. I appreciate it. Yeah. Well, my only thing with that is I would have hoped, and maybe this is just me being picky, and like I said, hindsight 2020, me not having 800 million different cases on my plate in multiple different jurisdictions, and that's an exaggeration. I don't come at me in the comments, or come at me. It helps with the algorithm. Either way. It's one of those situations where it's like, I would have expected if they had more to get around immunity, because you had to know that he was going to hide behind immunity, that they would have put it in the initial complaint, and it just wasn't there. Which is, I'm hoping that Randy has a comeback, and he has a comeback of a lot of stuff, but it begs the question, and I think I asked this question to the person I was talking to, and they just never either had the time to respond, or I just didn't see it. If Randy had all that to begin with, why didn't he just put that in the initial complaint? But maybe that's just me being picky. It could just be me being picky. You know? Because I am picky when it comes to, like, motions and shit, when you have a degree that's supposed to be smarter than me. I don't know. Like, I hold people to a high standard. Which is one of the reasons I like to make fun of Bubbles, because he obviously doesn't meet that standard. Plus, he made fun of my kid, so. All right. November 5th, 2025, the court issued plenary summons to serve defendant Luthman pursuant to Florida statutes 48161 and 48181, to which permit substitute service of process on non-residents through the Secretary of State. Plaintiffs have now initiated the substitute service process by submitting service documents to the Florida Secretary of State on November 23rd, sending the required documents to defendant Luthman via FedEx, a commercial firm regularly engaged in the business of document or package delivery, on November 24th, and sending the required documents to defendant Luthman via email on November 24th, all in accordance with Florida Statute 48.161. Plaintiffs are currently awaiting confirmation of service from the Secretary of State, after which plaintiffs will file an affidavit of compliance as required by Florida Statute 48.161, all with deliberate speed. Plaintiffs require an additional 40 days beyond the current November 25th deadline to fulfill all requirements of Florida Statute 48.161 and to file the necessary affidavit of compliance. Good cause exists for granting this extension because plaintiffs have demonstrated diligent efforts to serve defendant Luthman. Defendant Luthman appears to be actively evading service. Plaintiffs have initiated the substitute service of process in accordance with Florida law, and additional time is needed to complete the statutory requirements for substitute service. FRCP 4M provides that the court must extend the time for service for an appropriate period if the plaintiff shows good cause for the failure to serve within the specified time. FRCP 6B further authorizes the court to extend the time for good cause shown when a request is made before the original time for its extension expires. Wherefore, plaintiffs respectfully request an extension of 40 days without limitation, filing an affidavit of compliance for the requirement of 48.161, grant other such relief. I'm going to just take this off the screen real quick so that I can make sure that I don't have to, because I did not get the chance to redact these, and because I'm an asshole, but I'm not like, I'm not like a super dick. So I'm going to, redact addresses, especially because there's an address of the server in here, and that person is not even close to being responsible for any of this crap. So I really don't want to ooh. I really don't want to uh oh, this shit gets weird. All right. Do. Because um do. I'm just checking that I have all of these addresses because there's a lot. He's been attempted to be served at multiple places. Whoopsie. All right. Me thinks me got it all. Oh, nope. Forgot a page. Jesus. And I'm sorry. I just got this one, or I just downloaded it like 10 minutes before, and I was on the phone and trying to do family stuff at the same time. It's just crazy. You ever have days like that where you're like in 800 million places at once and redacting a document was not on the agenda? Do. Angel, I hear you. We're almost done and then we will eat dinner. All right. We're going to go back up to here. So this is proof of service on 11. What's up, baby? Who's up, honey bear? Okay. Defendant not at known address. All right. So page 2. What? Not a super dick? Then why am I here? Hey, Freckle Ginger, thanks for the $5 super chat. I don't support mediocre dick. Rage quit, stage right. Oh my goodness. Hey, Harry. Thank you. I just straightened my hair. It's a foreign concept lately. Baby girl, gotta turn that volume down. All right. And hey, Jill. I have most of the time. Sometimes I wonder why I should just stoop to some other people's levels, but then I'm like, I have professional certifications to maintain, and those have codes of ethics. So I'm like, maybe I should just not be a dick. On November 3rd at 6:30, process server attempted to call Richard Luthman, and we've seen this. Went to voicemail. November 4th, we've seen this. We've seen before. 12:12 p.m., Mr. Luthman texted the process server a screenshot of what he posted over the internet. The text was supported by a Gab server and stated, "Help, that Eugene Griffin of G-Man Private Investigators broke into a home in Florida and touched a child inappropriately. The family of the child needs your help. Need your help." Because he can't use grammar when he's, if you're going to be that kind of person, you can't use a. Yeah. The screenshot also included the process server's Valley Association page with his name advertised. And let me go to non-redact so I don't accidentally redact more stuff. 1:31 p.m. Luthman texted the process server again. Text message read, "Hello, since you have declined to correct the statement, I will leave it up as accurate. Thank you." What a dick. Well, his name is Richard. Sorry, anybody out there named Richard. November 8th, process server attempted to serve summons in a civil action by going to the address in New York. Florida process server contracted with this process server in Staten Island. And these results, see page 3. Service was attempted, no answer. 11:08, 11:10. Per doorman, the defendant is not known at this address. deponent showed a picture of the defendant to the doorman, who stated that this person does not look familiar and a female resides in the subject apartment. Like, just, yeah. We've seen all this, 5'9", 621. Like, it, all these different things. 6th day of August. Same time, 8/12, 8/16. Return of non-service. Like, all of this. Affidavit of non-service. And sorry, I messed that one up. Between August 12th and August 15th. Despite diligent efforts and multiple investigative approaches, unable to personally serve the defendant. Based on totality of evidence, including avoidance behavior and vague statements made publicly by defendant, I believe the defendant is intentionally evading service. Like, it, yeah, it just goes into more of the same crap we've already seen. Yeah, I just, this is the, I do want to show this. Hey, Duncan, Idaho. Thanks for being a member for 14 months. Richard is a good, strong name, except for Dick. Randy, pocket rocket shocket. I mean, although kind of rude, kind of funny. And I'm hoping Randy laughed like, you stupid. Thanks for the entertainment. But your purported notice is rejected and Toto? What are you, freaking... I had so much to say. Once again, not appropriate. Per purpose is legal, media, entertainment, and other. The purported address is not my address for any purpose. Do not accept or consent to service via email. I have no authorized agents authorized to accept service on my behalf. You don't get that choice. I demand strict compliance with FRCP Rule 4 per 11th Circuit precedent, which requires a constitutionally compliant, jurisdictionally achieving act. Note the summons your moronic client had issued. Name calling, not nice. Not nice when you're being sued. Like, not nice when you're being sued. Like, and that remains part of the court record, has me a resident of the state of New York. You have not attempted to serve me in New York, and you haven't amended. Well, they did. Your client have harassed others with my name in the state of Florida. You both have harassed senior citizen Floridians, and you want Judge Zachary Belitho to co-sign your unethical bottom feeder tactics. Florida protects its seniors. That's up for debate. Florida also rejects anti-Semitism, protects Jews, and stands with Israel. Oh my God. Like, okay. Not necessary. Like, not necessary. Like, whatever you think. Why do people inject politics into things that politics are not supposed to be in? Like, this is a lawsuit that has to do with you being a dick. Yeah. He sent something that acknowledges he knows about the case. And that's... I know a guy called Pocket Rocket. He's always in and out before you know it. I've already alerted Governor DeSantis. Let me know how much Governor DeSantis cares. Senator Scott. Who cares about him? Congressman Donalds. Attorney General Uthmeyer, the Florida Bar, and the president's people about you and your client. Our client's 90 days have run. Oh, that's taunting. Why when you act like a dick, don't put it on the freaking internet and don't put it in a freaking email or a text message? Have we not learned anything? We not learned anything. Your client rejected my good faith offer to cure. In sum, you and your client can both eat a... Also, you'll both burn in hell for what you're doing to... Oh my God, and his sick wife. Well, Jesus came... Sorry. I'm sorry. I do not believe... You can believe whatever you want, but I do not believe that Jesus came to him in a dream. Oh my God. Oh, sweet Jesus. Sweet baby dumpster Jesus. Oh my God. I just can't even read this without like cringing, because this is just cringe. Told me that he has removed all protection from Jeremy Hale and all who were in a league with him. No. And no, because that's not what Jesus does, you dumbass. Sorry. Oh my god. Yeah, oh my god. You would think that would count. Like, you would think that would count. In 2025, that shit should count. But I'm convinced the law takes like 20 to 30 years to catch up with reality. Like President Trump, I am protected by God. He will rescue me from all the nets of my foes. Oh my cringe. Like, this is like cringe level 10,000.
Oh, mommy.
What's up?
I can't.
Okay. Thank you for your attention to this matter. Oh my god.
I can't.
Oh my god. Yeah. Y'all just I just can't. So we've officially hit the do you like it? We've officially cringe level 1000. So with that being said, please don't yeet me before I'm ready to yeet myself. I just this is just cringy. Like when you think it can't get any more cringe, here we are. We are cringy. However,
Oh.
oh, hi. Yep. Oh, it's like all right. So, we have nothing else to cover for today. We have finally made it through that. Yep. So, put away your pitchforks for the day. You can be mad at me tomorrow. We have Pretty Petty and the Seeker coming up tomorrow. Hopefully, my Pretty is feeling well. Ma'am. Hopefully, my Pretty is feeling better and Spawn will be here. But we finished our cringe level today. So yes, just please put away your pitchforks. And we will see you on the next one. Y'all have a great day. You want to say yeet?
Eat.
1,
2, 1. Bye.